All right, folks, welcome to the Taking the Lid Off podcast. The quote today is: You carry a gun, so you're hard to kill. Know the law, so you're hard to convict. And today's guest is attorney Andrew Branca. Am I saying that right, Andrew? Branca?
That's perfectly fine.
Gotcha. So Andrew is an attorney, and he's got a book called The Law of Self Defense, the Indispensable Guide for the Armed Citizen. And it's an invaluable resource for knowing the laws of self-defense. So, how does that fit into the show? So, talking about veterans, as veterans, when we deploy downrange, we have rules of engagement, and guys come back, and a lot of military veterans, I would say a very high percentile, are folks that are interested in self-defense and are people who carry a gun. So, I think it's important to talk about the laws of self-defense in this country versus the rules of engagement that we have to deal with in other countries, because I think the gap is closing as of recent between the laws you have to obey downrange versus the laws here. But anyway, that's what we're going to talk about, because we want to keep you informed and keep you from having to get some soap on a rope or anything like that, going to jail. So, Andrew, if you would just give us a brief intro, tell us a little bit about yourself.
Sure. So I'm an attorney. I have a rather unusual law practice. I specialize in use of force law, nothing but use of force law. So I don't have a traditional criminal defense practice. I don't do DWIs or anything else, only use of force cases. In fact, I don't take clients directly at all. All my clients are represented by other attorneys who are their lead counsel, and I'm essentially a legal consultant to attorneys all over the country on use of force cases. Um, and this is all I've been doing since I want to say 1997, 1998. So it's been quite a while now. More in my third decade now of doing nothing but use of force laws as a legal practice. To my knowledge, I'm the only attorney who has that focus and specialization in the entire country. Plenty of criminal defense attorneys do self-defense cases, but to my knowledge, none of them do them exclusively.
Gotcha.
Um, so, of course, as you mentioned, I've written books on the subject, The Law of Self-Defense, third edition. We do a lot of live instruction. We do webinar instruction. We have DVDs. We do the legal consultations I already mentioned. We do a lot of blogging, podcasting right at our Law of Self-Defense website, which is simply lawofselfdefense.com. We have new content there pretty much every day. And all of it's freely accessible on the day it publishes. Now, the second day after it publishes, it is locked down for members. We do have free memberships as well. But if you go to the website, there's almost something there available for free for people to help educate themselves on self-defense law. And the reason we do this, kind of our mission as a law practice, is partly to help consult on legal cases for people who've used force, found themselves criminally charged, or looking typically at 10 or 20 years in prison because of a felony criminal charge, usually assault and battery or some variation thereof, sometimes murder, manslaughter. But what we really hope to do, our priority is actually teaching people the law of self-defense ahead of time so that they're well positioned to not only win that physical fight in self-defense, but to make themselves less vulnerable to being prosecuted in the first place in the legal fight that can follow winning that physical fight. So the best protection, I mean, you don't want to be at criminal trial on a felony charge. It's incredibly costly and destructive. And of course, there's always the risk that you could be convicted. Just like being vaccinated against a disease, it's far better not to find yourself in that position in the first place. And the good news is that self-defense law in America is not that complicated. It's relatively simple if you know what it is. And all you have to do is stay within those legal boundaries. And if you can do that, just stay within those clearly defined legal boundaries, it's awfully hard to convict you for a use of force charge. Unfortunately, what people do is they don't know where those legal boundaries are. They think they do. They often think they do. But they don't actually know where the actual legal boundaries are. They step over those legal boundaries not out of malice, but out of ignorance. And I don't mean that in a derogatory sense. I mean that in a technical sense. They're technically ignorant of where the legal boundaries are. So they step over that line without ever realizing they're doing it. In fact, one of the most common things I hear from clients in the cases we talk about is they can't believe they're getting prosecuted for self-defense. Because in their heads, they genuinely believe that their use of force was lawful self-defense. Unfortunately, they're often technically mistaken. It simply doesn't qualify as a technical matter. as self-defense under the law. And self-defense is what we call a perfect legal defense, meaning if you meet the conditions, it doesn't just reduce your criminal liability, it eliminates your criminal liability. Your use of force, even if you took another human life, was simply not a crime if you meet the legal conditions. Unfortunately, it's like a light switch, it's either on or off. If you don't meet the legal conditions, you don't just lose a little bit of self defense, you lose that legal defense of self defense entirely. And then you have no legal defense, and you're simply guilty of whatever the criminal charge was: murder,
Right.
manslaughter, aggravated assault and battery. And of course, these are high stakes charges. I mean, most of the cases I work on are aggravated assault cases where no shot was fired, no force was actually used, but somebody pointed a gun at somebody else. That's aggravated assault with a firearm. And in most jurisdictions, that's good for at least 10 years, maybe 20 years or more in prison. And you'll go to prison. So
Right.
important to know where those legal boundaries are so that you don't step over them out of ignorance. You stay well within those boundaries and make yourself, as we say, hard to convict.
Right. Yeah. I mean, and that's super important too. Talking about you don't necessarily have to pull the trigger. Just having the gun out and pointing the gun at a person is something that you've got to think about as well. Yeah, and the points you made are I mean, I love hearing this stuff because I used to teach the North Carolina concealed carry course. I got certified and did that, and in North Carolina, you were allowed to kind of come up with your own presentation. And so in my presentation, I would put videos. I'd steal videos off YouTube of self defense scenarios that were recorded, and it would amaze me at what people thought was perfectly legal. Just one quick example, there was a situation where some robbers get out of a car, they push a couple into their house, they go in the house, and this is a camera, a security camera from outside. Next thing you know, they come, the robbers come running out, and there's a guy chasing them. They get in the car, and he's still shooting at them as they're driving away down the street. So this guy's shooting rounds down a street where in a neighborhood. And I would ask people, okay, what do you think? And there'd be at least half the people would think that that was okay. Um, you
Oh,
know, and obviously it's not, right?
that's correct. It's not. Um,
Yeah,
yeah, that's the real problem. Unfortunately, it's my observation, and I have been a firearms instructor myself. Technically, I'm still an NRA firearms instructor, although I haven't done that work in a long time. But it's been my experience not so much that people aren't taught or don't know self defense law. They've often been taught quite a bit. They've gone to a number of training classes, they've learned quite a bit about self defense law. Unfortunately, what they've been taught and what they've learned is wrong. It's bad information because the person who taught them didn't really understand self defense law. They're just repeating what they were taught by someone else who didn't really understand it. No one's looked at the actual law, the statutes, the
right,
jury instructions, the court decisions, because frankly, it's hard to do. A lot of that stuff is just legalese. And if you're not trained in legalese, it's difficult to understand what any of that means. I mean, I've been in a lot of concealed carry classes where the instructor gets up to the legal portion of the class and he ends up reading a bunch of statutes to the class, and nobody knows what any of that means. No one can apply that stuff under
right,
stress. It's just not really helpful. You need someone to translate that legalese into plain English so people know what it actually means. And by the way, just reading statutes is extremely dangerous because
mm,
statutes don't mean what their apparent plain English reading would suggest that they mean. They don't
right,
mean what the legislature might have hoped they would mean when they passed it. Statutes mean what the courts that interpret and apply those statutes say they mean. And
right,
that's not necessarily the same thing as what they appear to mean. It can be two quite different things. And so I always caution people, if all you've done is read the relevant self defense statutes for your state and you haven't read and understood the court decisions applying those statutes, you have no idea what those statutes actually mean because
right,
it doesn't necessarily mean what the words on paper would suggest.
right. And yeah, and listening to so I guess to kind of back up, Andrew and I met at the first American Warrior Society. Andrew does some consulting and work with American Warrior Society as far as law of self defense. And at the first, they have an annual warrior camp, and at the first warrior camp, Andrew came and did his presentation, and it was great, and it really opened my eyes, and that's kind of what that was part of what motivated me to go ahead and start teaching those courses in North Carolina when I lived over there. partially was so that I could do it for soldiers, and because I was in the army at the time, I was doing it for soldiers and their spouses, and doing it for a very fair and cheap rate. But also, to me, when I heard you speak, like the knowing the laws is so important. And again, we're going to talk repeatedly about Andrew's book, but I want to reiterate: get this book. Um, look up Andrew Branca, find him Law of Self Defense online, and we're going to give all those links in the show notes and everything. But so important to learn this stuff. It's not, you can't listen to the good old boy down the street, right? That's where all that bad information comes from. I feel like, and they just don't know. They don't know what you don't know.
It comes from the internet. It comes from kind of the mythos of self-defense law that instructor for decades on end. Frankly, a lot of it comes from prosecutorial discretion. So prosecutors have a lot of discretion in whether or not they're going to charge somebody with a crime for use of force. And it's not uncommon to read about some use of force event in the paper. And then you learn that the prosecutor decided not to charge that person. And the reader of the story says, well, what that person did must have been lawful because they weren't charged. Often that's not the case. Often what that person did was actually unlawful. But because they've never been involved with the law before and the people they used force against were known criminals, the prosecutors decided, that's not a case I want to take to trial, so I'm not going to charge them. But a different prosecutor on a different day, even in that same office the next week, the same facts, could decide to take that case to trial and argue it successfully. So you can't rely on what you read in the newspapers either to come to conclusions about what's lawful or not. If you're charged with a use of force crime, and typically, especially if it's with a gun, it's going to be a felony charge. So you're looking at a long time in prison. You're looking at a very expensive legal defense, even if you manage to avoid going to prison. I mentioned most of the cases I work on are aggravated assault cases where there's no shot fired, nobody hurt. The lead counsel in those cases is typically getting a retainer of $30,000 to $50,000 for pre-trial work, not to cover the cost of a trial, to cover the cost of getting to the trial. That's a lot of money.
Yeah, yeah.
Lionel don't have 50 grand sitting in a mattress someplace in case they get criminally charged for aggravated assault. And if you go to trial, it's going to be some multiple of that. And if you're going to trial, if you're being charged, nobody cares what you learned from the internet or what you learned from your neighborhood firearms instructor or the retired cop down the street or you read in a gun magazine. None of that counts. All that counts is what do the statutes, court decisions, and jury instructions in that jurisdiction say, period. And your good faith, that you had a genuine good faith belief that you were acting in lawful self-defense, doesn't count, folks. That doesn't matter. All that matters is whether or not your conduct was actually within the legal boundaries. And if you don't know what those legal boundaries are, you have no idea if your conduct falls within them or not.
Right. No, that's great stuff. So, Andrew, one thing that I kind of wanted to talk about today is, kind of as talking about military veterans, and we go downrange and we have a certain rules of engagement that we go by. Are there any cases that you know of specifically that may involve a veteran and and a self defense claim?
Yes, I do. In fact, um, give me just a minute here. I have a
Okay.
specific case in mind that I want to talk about, uh, but I don't have a convenient way to point your listeners to it. So, but I can set that up in just a moment. So, this
Okay.
is a case I'll talk over while I'm setting this up. Um, if I can figure out how to do it quickly. Yes. So, this is a case involving a Marine who's now out of service, back in private life. Let's see. The name of the case is State v. Grott, and I will set this up so your listeners and viewers can get a hold of it, the actual case itself, so they can read the actual case. Let's see. And let me just check that out to make sure that works. lawofselfdefense.com/. Yep. Okay. So if your readers want to read this actual decision, and I've added to the decision kind of a little summary at the beginning to kind of provide some context and explain what's actually happening in the case. This case is State v. Grott. It comes out of the Washington Supreme Court. So it's a state Supreme Court decision. from February. So just last month, folks. This is a brand new appellate court decision that was handed down. And if you'd like to read it, you can just point your browser to lawofselfdefense.com/grot, GROTT, and it'll pull up that decision for you. And as I was saying, this decision involves a Marine out of service, back in private life. But in his social circles, he finds himself associating with someone who's not a very nice person. They have an acrimonious relationship. And the Marine comes to believe that this other guy intends to shoot him and kill him the next time they run into each other. And sure enough, they run into each other. And it turns out the other guy does have a gun on his person. And the Marine sees this other guy. It's unclear whether or not he sees the other guy has a gun, but he feels he doesn't need to see if the other guy has a gun. He believes, the Marine believes this other guy intends to shoot and kill him the next time they see each other. And now they're seeing each other. So what does this Marine do is essentially he goes into a full-on assault on this guy. He's got his own gun. So he starts shooting at the guy. He starts charging the guy's position. He goes through a number of magazine changes. He fires a ton of rounds at this guy who's sitting in his car. And those rounds are extremely effective. He ends up hitting the other guy 9 or 10 times, kills him in his vehicle. When they recover the body, they pull the body up and they find the other guy's gun under his body. So the other guy had a gun, never even had an opportunity to bring it into play. So from a pure combat tactical perspective, this was an absolute win by this Marine. He totally overwhelmed that other guy, his enemy, as he perceived him, and won that fight, decisively won that gunfight. Unfortunately, that may have been a perfectly legitimate exercise of firepower in a combat situation, but it is not a perfectly acceptable course of action in a civilian self-defense situation. It's vastly disproportionate force. There's a number of requirements of self-defense that were not met. And in fact, this Marine was charged, and found guilty of second-degree murder, multiple counts of assaults, firearms enhancements, and he's currently serving 50 years in prison. And the reason we have this is because he appealed his conviction in Washington State all the way from the trial court to the Court of Appeals, from the Court of Appeals up to the state Supreme Court, and every court affirmed his conviction for second-degree murder and is sentenced to 50 years in prison because although his use of force was tactically overwhelming and decisive and successful, it falls outside the legal boundaries for lawful self-defense for a civilian and constitutes murder. And he'll spend the rest of his life in prison as a result. And that just didn't have to happen. You can successfully defend yourself within the legal boundaries and not end up with a second-degree murder conviction and a 50-year prison sentence.
Wow, that's terrible. Yeah. So with that, I'd like to go ahead and get into the book. So now, since that's fresh in the listener's mind, something like that, a case like that, I'd like to go ahead and get into the book here. And the 5 elements are kind of the first thing I'd like you to discuss. Just give us a little brief about.
Yeah, so we spent most of our time so far talking about the kind of the dark side of self-defense, the consequences if you do it wrong, which are pretty severe, as we've just described. This Marine spending the rest of his life in prison, effectively. But there's good news too, and the good news is that the legal boundaries for self-defense, those lawful boundaries you need to stay within, are not complicated. There are not 500 things you need to keep in mind. There's not 50 things you need to keep in mind. There are only 5 conditions, up to 5. Sometimes not even all 5 apply, but there are only 5 conditions for your use of force to be perfectly lawful and for you to have zero criminal liability for that use of force. And they're what I call the 5 elements of self-defense. In fact, I would encourage people, we get questions about this so much, we have a little infographic that we make available for free that kind of generally describes those 5 elements. And folks can download that at lawofselfdefense.com/elements, simply enough.
Oh, nice.
And I encourage you to do that. It doesn't cost a penny, folks. Lawofselfdefense.com/elements. Because if you don't understand these 5 elements, you have no idea whether or not your use of force is lawful or not. But there's only 5, and they're not that complicated. And the 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And in a nutshell, what innocence means is simply that you were not the physical aggressor in the fight, which makes sense, right? You're supposed to be defending yourself against someone else's aggression. You're not entitled to be the aggressor yourself. Imminence means the threat you're defending yourself against is happening right now. It's not some past threat that's over. It's not some future speculative threat. Proportionality has to do with whether we're talking about a non-deadly force fight or a deadly force fight. You can't use deadly defensive force against something that's not a deadly threat to you. Avoidance has to do with whether or not you happen to be in a jurisdiction that imposes a legal duty to retreat before you can use force in self-defense. There's about 13 of those, 13 states that impose that legal duty. And reasonableness has to do with whether your perceptions, your decisions, your actions in self defense were those of a reasonable and prudent person. And that's it. Those are the five. Uh, Now, sometimes not even all five are required. For example, the element of avoidance, whether you have a legal duty to retreat, about three-quarters of the states don't require that element, in which case you only have four things to keep in mind. But you do have to keep them in mind because they are cumulative, meaning whichever elements are required, well, they're required. And in order for a prosecutor to defeat your claim of self-defense, he doesn't have to destroy it entirely. He has to destroy any one of those required elements. If he does, it's like a chain. You break any link in the chain is broken. If he can destroy any one of those elements, the required elements, your claim of self-defense disappears. And keep in mind, when you claim self-defense, you're justifying a use of force of self-defense. You're not saying it wasn't me. Someone else did it. I was someplace else. I have an alibi. That's not what you're saying. When you claim self-defense, you're saying it was me. I shot that guy, but I did it in self-defense. Well, if the prosecution destroys any one of those required elements and your legal defense of self-defense goes away, what's left of that statement? I shot that guy. That's it. It's
Right.
effectively a confession. So if you're in a self-defense legal argument and you lose self-defense, it's an easy conviction for a prosecutor. So the good news is there's not that stuff to keep in mind. It's only up to five elements, but you better have those five elements because if any of them are vulnerable to attack by a prosecutor, self-defense goes away and all that's left is a conviction.
Right. And I think reasonableness is probably the one that in my experience, gets talked about the most, and some of those others don't get talked about quite as much when you're, listening to the internet gurus and whatnot. People seem to understand, it has to be reasonable. I think, but again, folks, like I don't want Andrew to go too deep in that. I want you to get the book for one, because you really need to deep dive into that stuff and get in the charts too. You said lawofselfdefense.com slash what was it?
Elements.
Elements. Okay. So go get the chart and look at it, but you also need the book. You need to deep dive into that stuff and know it so that again, so you're hard to convict. So you've got the elements, but I think one other important one for military folks especially would be defense of others, because on the battlefield, defense of others is a much different thing, because you're a team, and you're working together and all that. But in the case of being a civilian, it's it's a little different here. So can you just talk briefly about defense of others?
Yeah, so in one sense, from a black letter law sense, defense of others is pretty simple, pretty straightforward. In effect, you're allowed to use force in defense of another person to the same extent you'd be allowed to use force if you were that person facing the threat, if you were in their position. So if that other person would be entitled to use deadly force in self defense, you'd be entitled to use deadly force on their behalf. Sounds simple, right? Where it gets complicated is not really in terms of the law, but in terms of a practical reality. And there's really, I urge people to think about defense of others not as some kind of homogenous scenario, but there's at least three different categories of defense of others, and one of them's really problematic. Two of them are not really problematic. The problematic one is when you come to the defense of a stranger. You turn a corner, you see a fight, you don't know any of the people involved, but it looks like someone's the victim of a violent crime and you decide to intervene. Well, unfortunately, if it were to turn out, for example, that the person you defended, unbeknownst to you, was actually the person who started the fight, they were the aggressor in the confrontation. They just happened to be losing at the moment you see them. Well, if they started the fight, they would have no right to claim self defense themselves. In that case, you may not have any right to claim defense of others on their behalf. So if you've threatened or used force, you have no legal defense to justify that use of force. And it's not because you acted out of malice. It's because you didn't know what was actually going on and you didn't know that one of the check boxes to justify your use of force hadn't been checked. It's the ambiguity and the uncertainty of the situation. Also, if any of your listeners have ever been involved in law enforcement, they've responded to a domestic call at one point or another, and they're well aware you can go to a domestic, come to the defense of the abuse victim, be arresting the abuser, and suddenly the abuse victim's attacking you for arresting the abuser. So another concern is the person you defended, when the cops show up, they may tell a very different story to the cops than what actually happened. And if the
Right.
person you quote unquote saved is telling the cops that, hey, they were never really worried, they were never being threatened. The only time they got really scared is when you showed up and started waving a gun around. What are the cops supposed to think? Right? And then it
Right.
really it's like you're the crazed gun nut in the cop's eyes.
Right. The
So
defensive other ones can be a scary. That can
it
be scary.
really can. So I do want to distinguish between that kind of defensive strangers scenario from two other scenarios that are less problematic because they're less ambiguous. One is when the person you're defending is not a stranger. They're somebody known to you. They're a family member. They're a close friend. They're a work colleague. So you know something about their character. Their interests are aligned with your interests. They're unlikely to lie. So you go to jail, for example. You know that they probably, your mother probably didn't start a fist fight in the convenience store, right? If she's getting beat up, the other guy was almost certainly the aggressor. So you don't have those ambiguity concerns there. So I don't consider that a dangerous defensive other situation. On the other extreme, also I think less problematic is the ultimate extreme defensive other situation, and that's an active shooter situation. Remember, the defense of strangers situation is dangerous because it's ambiguous. You don't know what's going on. It's unclear who may have been the initial aggressor, for example. In an active shooter situation, if you're in a mall and some guy's walking around with a long gun shooting people laying on the ground, there's no ambiguity in that situation. It's very clear that he's the bad guy. So there's virtually zero legal risk in interjecting yourself in that fight using force against that particular guy in defense of other people in the mall. Now, there is risk, of course, and all your watchers in the military will be well aware of this. You're getting into a gunfight. So if you're getting into a gunfight, that's dangerous. People die. In fact, there was just a story in the news this week about a good Samaritan, well-intentioned fellow who decided to chase a bad guy, and the bad guy shot him when he caught up with him, killed him.
I saw that. Yeah.
Yeah. So getting into gunfights is dangerous. You get into a gunfight, there's a good probability you're going to get shot and maybe killed. Now, I'm not saying that's a reason not to intervene in an active shooter event. It's just one of the things you need to take into consideration. That's the risk you're running. But it's not a legal risk. It's a survival risk, which is
Right.
important, but
Right. Yeah.
outside my area of expertise.
Yeah. I used to tell people all the time, you win 100% of the gunfights that you're not in. So do your best to not be in a gunfight. Number one, however, whatever techniques or tactics or whatever you may use to not be in a gunfight, please. Um, but all of this stuff as well, we kind of focus on guns a little bit, but all this stuff, it applies to self defense, period, right? So we're talking a gun or a bat or a knife or any of that, really.
So
Correct?
for purposes of, I always have to be very careful to tell people that my expertise is use of force law, not gun law. So I don't, I'm a gun owner. I carry a gun for personal protection. I have my entire adult life. It's very routine for me. I've never had to come even close to using that gun, but every day I've got it on my person, just like I wear a seatbelt in a car. But I know as much about gun law, meaning licensing law and what you're allowed to own and not allowed to own, as any typical gun owner. Just what I need to know for my own purposes. But gun law, what guns you're allowed to have, what licenses you need, what you're allowed to carry, that's completely different from use of force law, which is my area of expertise. Use of force law doesn't really care what the implement of force is. It doesn't care if it's a gun or a knife or a bat or anything else. All it cares about is the force you're using deadly force, meaning force capable of causing death or serious bodily injury on the one hand, or is it non-deadly force, something less than that, some force not readily capable of causing death or serious bodily injury? All use of force cares about is which bucket are you in, non-deadly force or deadly force. Once you're in the deadly force bucket, the law doesn't really care if it's a gun or a bat or a knife or an anvil dropped from a great height. It doesn't really care. All deadly force is equivalent to all other deadly force for use of force law purposes. So yeah, everything we teach applies to whether you're using a gun or one complicated area happens to be impact weapons for guys who have batons or expanding batons, because those can so easily slip from one bucket to another, right? If you're striking
Hmm.
someone in the hips or thighs with a ass baton, well, that's a non-deadly use of force. But you strike
Yeah.
him in the head with, it's a deadly use of force. Same tool, but it's
Right.
the application that determines whether or not its use would qualify as non-deadly or deadly.
Right. Yeah. Yeah. I think in law enforcement circles, you typically will have these diagrams that will show kind of what's considered deadly force and what's not when it comes to striking. If in their teachings about batons and whatnot. But so the other thing that I kind of want to talk about was defensive property, because that's something too that is very different overseas. You can defend property typically overseas because you're talking about sensitive items and different things like that. Uh, and but that varies by states here. If I'm right, am I correct in that the defensive property varies by states here?
Well, not really,
Okay,
except for the state of Texas is the
right.
only exception. But for 49 states, we need to differentiate property between just personal property, which is just items, things you can carry around like a cell phone or a laptop or an unoccupied car. Uh, Personal property you can only ever defend with non-deadly force. You're allowed to use force to defend that property to keep someone from stealing your laptop, for example, but only non-deadly force. You can't use a gun to defend that stuff. And by the way, pets. I know people who have pets feel like pets are members of the family as much as the human beings in the maybe more than the human beings in the family. I guess
Yeah,
depending on beings in your family. But under the law, pets are personal property, so you can only use non-deadly force to defend your pets from a person's attack.
interesting.
Now, of course, if you're with your pet, uh, it's not hard. The dividing line between someone attacking your pet and someone attacking you is pretty narrow. But if you ended up using force against that person, especially deadly force, you'd want to explain or have your lawyer explain that no, he wasn't using deadly force to protect his pet. He was using deadly force to protect himself because that's a different threshold. But if it's only your pet, you're defending only non deadly force. The one exception to that is Texas. Texas is the only state that has any legal provision for the use of deadly force in defense of personal property. For those who are interested in reading the statute, I encourage you to do that. You can find it at lawofselfdefense.com slash the numbers 942 because it's Penal Code 942 under Texas law. But even under Texas law, there's a lot of loopholes that have to be jumped through, a lot of boxes that have to be checked. So, for example, the theft of the property has to be happening at night. The property has to not be reasonably recoverable by other means. There's a lot of check boxes you have to hit in order to be justified under that defensive property provision. And if you miss any of the check boxes, it's just like missing any of the check boxes in self defense. You lose the justification. So if you shot and killed the guy and you missed one of the check boxes under that Texas 942 statute, you're just out of luck. You just don't have it. So you have to think to yourself, all right, well, you shot and killed somebody, totally lawful if you've checked all the boxes, but you're going to jail for the rest of your life if you missed one of them. Is that worth it? What pieces of personal property are worth that risk? I would suggest not much. So even in Texas, I discourage people from doing that. And of course, in the other 49 states, they don't have any legal provision like that. So deadly force in defense of property is simply unlawful in defense of personal property. Now, there is another category of property called highly defensible property, and this includes things like your home. And most states have special provisions for the use of deadly defensive force in the context of your home, where your use of deadly defensive force would not be lawful if you were just out on the street and did the same thing. But that requires conditions too. And typically, the triggering conditions are that the person you used force against was forcibly and unlawfully entering your home. If they're doing that, man, that's a very difficult use of force situation for you to mess up. You can do just about anything you want to that guy and it'll be lawful. But they have to be forcibly and unlawfully entering your home. If they're just standing on your front porch yelling at you, well, they're not forcibly and unlawfully entering your home. We just had a news story this week about the husband of the district attorney of Los Angeles had some protesters out on his front porch. He opens up his front door, points a gun at them. Uh, well, if they were trying to break into his house, that might have been perfectly lawful. It probably would have been, but they weren't trying to break into his house. They were just standing on his porch. He got arrested. Now he's the husband of the district attorney. Politics gets involved. He'll probably be treated pretty leniently. But if it were you or I under California law, where that happened, we'd be looking at a minimum of 9 years felony time in prison, probably quite a bit more than that because the gun was pointed at multiple people.
Wow.
So defense of personal property, non-deadly force only, except for Texas, as I mentioned. Defense of highly defensible property like your home, they lower the threshold for using deadly defensive force. They give you just about everything you need to justify that use of deadly defensive force. but that person better be forcibly and unlawfully entering your home, at least attempting to do so. Uh, if they aren't, then you don't get those special breaks, and you don't have that special privilege to use deadly defensive force, unless, of course, you can argue that it's just a straight up self defense situation, and there's a threat to you personally,
Yeah.
or an imminent threat to some other innocent person, and then it's not really a defensive property situation anymore. It's a defensive person situation.
Yeah. Yeah. That's an interesting one too. Um, and I probably should have preempted with this story, but a story that I had in defensive property from downrange was Afghanistan. I was there with a joint task force, and to kind of sum it up, we were going outside the wire, outside of our fob training, and we were shooting on we were doing some shooting on a firing range and some tactics stuff and all this. And typically, the Afghani kid, obviously, it's a shooting range, so there's not a lot around, but the Afghani kids would come gather around when you were training and or when you were about done because they love to pick up the brass, and we were more than happy to let them to, so we didn't have to. So, but this one particular instance, they decided to gather around and get a little close to us as we were cleaning up before we wanted them to because they were, they're trying to fight each other, trying to get this brass because they go and get money for it or whatever. And we had these Humvees that didn't have doors on them, and one of our guys from another element had brought a camera, and this was a camera that was used on missions as well. So I didn't know at the time, but presumably I have to think that it has a disc in it that has pictures on it that are sensitive. So this Afghani kid, he was a teenager. My guesstimation was 16, 17 years old, based on his size. Not even kidding. I look over and I see the camera and I'm thinking, all right, we need to get out of here. And I was telling the guys that we needed to get out of there because it was not a comfortable. They're not going to do anything. They weren't terrorists, but it just wasn't a comfortable situation. And the kid looks at the camera, and I look at the camera, and he looks at me, and in my mind, I'm thinking, surely not. He's not going to grab this camera. And there he goes, grabs the camera, and I mean, he made it maybe two steps before I got him by his little man dress, and he was not going to let go of the camera. I was doing a little bit of combatives or whatever with him, trying to get the camera away from him, and he had a death grip on this thing. So then I take him down and show him a little bit of the old ground game, and while one of my teammates wrestled the camera away from him, and I say all that to say, had this kid gotten away from me with the camera, and again, 16, 17 years old, so you don't want to. I wouldn't have wanted to at all, but legally, I could have shot and killed that kid and got the camera. And so that's kind of why we're talking here, and what I want people to understand, or veterans to understand. You can't, in most cases, you can't do that. And again, I didn't even hurt the kid. If anybody's worried, the kid may have been hurt. It may have gotten roughed up a little bit while I had him on the ground, but it was his own fault because he didn't want to let the camera go. But anyway, that's the kind of things that I'm talking about when I say veterans need to understand the laws of self-defense and how it differs from the rules of engagement that you have downrange. But that's all great stuff, and that's defense of property. It's you know I know people are worried about their Xboxes and whatnot, but I would say if a guy's running down the street with your Xbox, by the time you see him, probably just want to call the cops on that one and not engage him. But I tell people too a lot, and I assume you would agree with this, Andrew, just from listening to you so much. But it's one of those things, you have to train yourself in these laws, and you have to be prepared to to do things in order to not be in the gunfight. Because even if you're justified, you may not go to jail, but you're probably going to go broke.
Yeah. So, as I said before, most of the cases I work on are aggravated assault cases. And most of those cases, almost all of them, we end up getting the charges dismissed before trial. So the person ends up not going to trial. They end up not getting convicted. They don't end up going to jail for 10 years. So that's a win. And that cost them 50 grand. So even when you win legally, it's unbelievably expensive. And of course, you don't know that you're going to win until it's all over. I mean, you're in a fight, you're in a legal fight. You could end up getting convicted and then spending all that money and going to jail besides. So what's worth that risk? Even if you win the legal fight, it ends up costing you a lot of money.
Right.
Uh, and it's not within your control. It's within your control whether or not you get in the fight. I mean, hopefully, if you can avoid the fight, you'll do that. But if you put yourself in a fight, suddenly you've put your life, your bank account, in the hands of a prosecutor. Now it's totally within his discretion whether or not you're going to have to cough up 50 grand for a legal defense. That's his whim. There's nothing that prevents him from doing that. So you've put that decision in his hands. Do you want to do that? Is that prosecutor, are his interests aligned with your interest? Maybe, probably not. What if he wants to make a big case out of it? What if he wants to run for higher office? What if he has political reasons for wanting to bring this case? All of that outside of your control. What's inside of your control is whether or not you restrain your conduct within those legal boundaries. If you do, at least even if they put you through the process as a kind of punishment itself, it's very difficult to actually convict you and put you in jail. So they can still cause you pain, but they probably won't be able to get an actual conviction and lock you up for 10 years. But best of all, not to put yourself in that position in the first place, not to get engaged in the fight where you make yourself vulnerable to some prosecutor's whim on whether or not they want to prosecute you. Many of your readers might have seen a case recently just out of New Jersey where a licensed security guard in New Jersey just got arrested and charged for having a gun and having hollow point bullets, which are illegal in New Jersey, even though he's got a license for the gun. And his particular brand of bullets are not classified as hollow point by the New Jersey State Police. So there's no, and he's very well represented. He's got a very good attorney. There's no doubt in my mind they're going to end up getting these charges dismissed. But in the meantime, they're going to put him through that process as punishment. And believe me, that's not a ride you want to go on if it's at all avoidable. Now, if it's not avoidable, if the fight comes to you, well, then you do what you have to do. I always tell people, my area of expertise is the legal battle, but the physical battle is more important. That's the priority, right? You have to win the physical fight. If you don't win the physical fight, then nothing else really matters. But you don't want to win the physical fight just so you spend the rest of your life in a cage. You want to win the physical fight in such a way that you're well positioned for the legal fight as well. And it's kind of like being the big guy in the bar, right? If you're the big guy, people don't want to challenge you because you look big, you look scary, you look like you can handle yourself, unless they're psychopaths, of course.
Right.
Well, from a legal perspective, you want to look like you're a hard case to win. You want to look like you're hard to convict because prosecutors, you can think of them as being graded on their win-loss record. And most prosecutors, their conviction rates in excess of 90%, which isn't just because they're great lawyers, although many of them are great lawyers, but it's because they get to choose the cases they bring to trial. If your favorite sports team got to choose who they played in games, they'd have a 90% win rate too. Um, and so prosecutors don't like to take cases to trial unless they have a very high probability of winning. So one of the best ways of avoiding being at risk of going to trial is don't look like an easy win. Look like you're hard to convict. If you look like you're hard to convict, your prospects of going to trial are enormously reduced. And when I say look like you're hard to convict, I don't mean learn some legal tricks or some magic words to say to the responding officers. None of that's real. We don't teach magic legal tricks here at Law of Self-Defense. It simply means be hard to convict because you knew where the legal boundaries were and you stayed well within them. So when the prosecutor gets that investigative report from detectives, that looks like a tough argument for him to win. If it looks tough, the chances that you'll be targeted for prosecution go down almost to zero. They're never completely zero, but they get pretty darn low.
Yeah. I mean, those are all excellent points, and I hope people are really listening to all this and hearing it and taking it in. You know, that, and to bring up one of your other points there, like I say, you win 100% of the fights you're not in, but the caveat there, like you said, is you still want to be alive, so you don't want to overthink things to the point that you end up dead because you were indecisive and worried about the trial. But it all comes down to preparation. One of my favorite sayings too is preparation equals victory, and man, that applies to many things, and it applies in this as well. Um, I
Yeah,
want,
what we always urge people to do is learn these five elements of self defense, learn why they're important, how they're typically violated, how people typically get in trouble so you know not to do those things. And then whenever you read about a use of force event on the internet or in a newspaper, if anybody reads newspapers anymore, uh, use that event as a training opportunity for yourself. Look at that. Now, the newspapers, the media always gets these stories wrong. The facts are always wrong. I've never seen them get it right yet. But ignore that. Just pretend that they're getting it right and use it as a training opportunity. Say to yourself, all right, Andrew talks about these 5 elements of self defense: innocence, imminence, proportionality, avoidance, and reasonableness. Where are they in this fact pattern? Which ones are strong? Which ones are weak? What could this person have done to strengthen their claim of self defense by strengthening each of those elements? And by going through that exercise, this is, for example, how pilots train themselves in preparation for um, malfunctions that happen in flight. They read about other pilots' accidents and they learn from those examples. Well, you can learn from the examples of others and train yourself. So if you find yourself in a similar situation, it's not the first time you're seeing it. Mentally, it's not the first time you're seeing it. Mentally, you've stepped through that exercise before and you have a general idea of what you're prepared to do and not do that will be within those legal boundaries. And that puts you several steps ahead of where you would have been if you're trying to figure out everything from a blank piece of paper now that you found yourself in some kind of confrontation. And I'm sure the military does similar kinds of training as well.
Yeah, I mean, you can take what I call mental reps, and I know it's maybe a little voodoo for some folks, but mental reps are very good for me. And I've done it with CQB, I've done it with all kinds of things. But what would I do? Okay, in this situation, what would I do? And even looking back, so I had a situation a couple weeks ago at a store up the road here. There was a gentleman that came in, and I just had that kind of hair on the back of my neck stand up, feeling that something wasn't right, and I kind of got myself to a position and observed, and he was being a little belligerent with the cashier. And I'm sitting here positioning myself to do what I need to do in case things go bad, because it did have a look that it could go from 0 to 60 very quickly. And fortunately it didn't. But afterwards I was thinking through, okay, what, the cashier was like a 16, 17-year-old little petite female. So I'm thinking I've got to step in, obviously, if something gets physical or whatever the case may be. So, going back and looking at those situations, if you ever find yourself in it, I think taking a look at those 5 elements, and in the army, or in the military, what we call after action review, do that and take a look and see what you did right, or what if this happened, what if it a little bit. I think is
Right.
a good exercise.
So at Law of Self Defense, every Tuesday we do a show. We do it on Facebook Live, and then we have the replay on our blog. We call it the After Action Analysis Show, and we take a use of force event that was captured on surveillance video, and we break it down in terms of these 5 elements to come to basically a plain English legal analysis of, was this use of force lawful or not? If it wasn't lawful, what might have made it lawful? If it was lawful, what might have made it not lawful? And we kind of explore the hypotheticals in exactly that kind of way. Um, and another thing for people to think about is one area I see people get in trouble a lot, uh, and it's not so much legal trouble as it is tactical trouble, actually. But they'll be facing some kind of threat, some kind of confrontation, and they'll go for their gun. Typically, it's a gun, and then they hesitate. Their draw is like halfway through, and suddenly they can't decide if they want to draw the gun or present the gun, or they don't know if what they're doing is lawful or not lawful, and they're trying to think it through, and it's almost like you can see the mental wheels in their head spinning in the mud, and they just can't figure out what to do. And then finally, the wheel will get traction, and they'll say, "Yes, yes, I want to present the gun." They'll get the gun out, they'll point it at the guy, maybe they fire a shot, but by then the guy's running away because a second and a half has passed or 2 seconds have passed. The situation's changed, but their brain is still working on what the situation was 2 seconds ago, which was different. 2 seconds ago, it might have been lawful to point that gun or fire the shot. Now, not so much, because the bad guy saw the gun and decided to run away, and they end up shooting someone in the back who's running away. And that's not self defense. And it's because they hadn't thought it through. They had that hesitation. So I'm the first person to say, man, if you can avoid getting into a fight, that's the best way to win a fight in the world. Simply
Right.
don't engage. But if you're going to be in a fight, you need to act decisively. So your brain has to be prepared to be, don't fight, don't fight, don't fight, don't fight. Oh, conditions have been met. Both the legal conditions and my personal moral conditions have been met. And then you have to fight 150%. There's no time for screwing around anymore because you have to win that physical battle.
Right.
But you have to know where that line is, because if you don't know where that line is, if it's some vaguely defined zone, well, that's where you get this hesitation, and that hesitation can be fatal for you or have really severe legal consequences if your brain catches up after circumstances have changed.
Right. So this has all been great information, and I want to I want to maybe go. I've had a couple of thoughts as we've been talking here, and this is a little off the rails from what our outline was, but so Andrew, do you remember the movie Con Air?
Sure,
Do you know what I'm going to ask you about in the beginning?
I don't remember. There's so
So
much of them.
so it's kind of funny, but you know Nicolas Cage, and he's this Army Ranger guy, or whatever. He comes home to his bride. This guy's messing with his bride, and he gets in a fight outside the bar. Do you remember that scene? And he,
Sure, that's how the movie starts.
yeah, and he kills the guy and gets convicted. And in the movie, they, I don't know if you remember or not, but they say, you know, because of his training, he's a deadly weapon and all this. So, in your estimation, is that something could could an attorney use that against someone from the military that has a certain level of training if they were in a self defense encounter like that?
Yeah. So anytime anybody ever asks me, can a prosecutor use X against you in court? I don't care what X is. The answer is always yes, because prosecutors are allowed to argue just about any thought that pops into their pretty little heads. If they want to argue it, they're allowed to argue it. It doesn't necessarily have to be rational. For example, most of your watchers might be familiar with the George Zimmerman trial. Zimmerman had killed Trayvon Martin. He was acquitted on the basis of self defense at trial. But one of the arguments the prosecutor made in that case is because they were trying to show that Zimmerman killed Trayvon Martin not in self defense, the prosecution argued, but with malice. So it should be second degree murder. And the prosecutor, to show malice, argued to the jury that not only did George Zimmerman have a gun, he had that gun with a round in the chamber in the ready to fire position. Well, what's that mean? Anyone who carries a gun for personal protection has a round in the chamber. Every bailiff in that courtroom had a round in the chamber. That's the normal way to carry a gun. So to suggest
Right.
having a round in the chamber indicates malice is ridiculous. But the prosecutor was still allowed to make that argument. So the prosecutor can argue about just about anything he wants. Now, could he argue that because you have special training, you knew that the force you were using, the blows you were bringing to bear, the techniques you were using were, for example, deadly force? You knew they were deadly force because of your training, whereas a person lacking that training might have thrown a punch, not realized it was deadly force because they didn't have that level of training. Sure, he can definitely make that argument. If some guy's being attacked and he defends himself and accidentally punches somebody in the throat and kills him, he might say, listen, that was completely unintentional. I had no idea that could result in somebody's death. That would be different than if you've been trained, hey, you punch someone hard in the larynx, it's a good way to kill them. And then you go ahead and do that.
Yeah.
That looks like you deliberately use deadly force against that person. So, sure, you can be treated differently based on your level of training, your expertise, your specialized knowledge. And frankly, it's hard to argue that shouldn't be the case, because if you actually possess those special skills and expertise and knowledge, well, then you're expected to conduct yourself consistent with those special skills, that expertise, and that knowledge. You're not uninformed. You actually are informed. So you're
Yeah.
going to be to the standard of someone who has that knowledge and expertise.
Yeah, and I was about 90% sure that that would be your answer, having listened to you so much, and that's why I asked, because I wanted the listeners to hear that, because that's absolutely correct. And so, and that also leads me into what you know, something else I think is
Now,
can be used.
I should
But
say, my vague recollection of the movie is that he was facing not just one attacker but multiple attackers.
I
Uh,
believe so. Yeah, yeah,
so the counter argument on his behalf would be not that he wasn't using deadly force; it was that I was using deadly force, but I was justified in using deadly force because I was facing multiple attackers, and the only way to defend myself against multiple attackers was to use deadly force to take them out as quickly as possible before they could overwhelm me. That would be a legitimate counter argument you could use in court. Of course, it's a movie, so we don't know what the arguments
right.
actually.
Yeah, a little Hollywood flavor on it there. But yeah, so but that also brings me to a point of, so like stickers. So you have, you know, you can drive. I'm in Knoxville, Tennessee right now, and I can drive up I-40 on Knoxville, Tennessee, and I can see an assault life sticker with a picture of an AR-15. I mean, that's something that could be used as well, right?
Well, the things I worry about in terms of stickers or phrases or icons people put on their guns, like a Punisher backplate on a Glock, for example. I'm not worried about things like NRA stickers or gun club stickers, but I do worry about things that go to state of mind, that indicate something about a person's state of mind.
Yeah.
Like their apparent willingness to use force, especially apparent willingness to use force outside the legal boundaries, like keep honking, I'm reloading, right?
Yeah.
Or kill them all, let God sort them out. Or that Punisher backplate. I mean, folks, think about who the Punisher is, right? I know it's a cartoon character, but the Punisher is a vigilante who deliberately uses force outside the legal boundaries. So you chose to put that emblem on your gun. Does that mean you think you're that guy? You think you should be entitled to use force outside the legal boundaries? Because I can assure you that's what a prosecutor is going to argue. Or even people who have these kind of terrorist hunting permit stickers on their windows.
Yes. Yeah.
Well, what happens if, heaven forbid, you find yourself in a deadly force confrontation with someone who happens to be Muslim? Is the prosecutor going to argue, hey, this guy was just looking for a Muslim to kill
Yep.
because he considers them all terrorists? It goes to your state of mind and your apparent willingness to use force. I always caution people, there's things you can put. We all like these funny stickers and things like that. And we know they don't mean anything. You're not actually going to shoot someone just because they're a Muslim. But listen, prosecutors are in it to win. And if you're handing them building blocks for a narrative of guilt, they're not going to pass those by. They're going to grab every single piece of building block you give them to construct a wall to lock you into prison. So don't give them those things. Putting, kill them all, let God sort them out on your dust cover on your AR. I mean, folks, just ask yourself, even if the prospects of it making you more vulnerable in the legal fight are small. Even though the risks are small, they exist. And what are they offset by? Does it help you win the physical fight to have that Punisher backplate on your gun or that sticker on your car? It doesn't. It doesn't do anything for you in terms of winning the
Yeah.
physical fight. So
Yeah.
all you're doing is increasing your risks in the legal fight for nothing. To be cute or clever, just please don't do that. You're only complicating your own future.
Yeah. To me, it's not worth it. I mean, you spend $20 on a backplate that's going to cost you thousands and thousands of dollars. While it may not get you convicted, you're going to spend the money to try to argue against that. And the assault life, when I brought that up, because that kills me. I mean, it literally says they're not, and I understand people are thinking about it from the context of assault rifle, you know, but you got that term assault life there. You really think that's smart? That's not smart at all. Assault life. I mean, that take it for what it is, and you're essentially you assault somebody, and I mean, attorneys just got to go look at this sticker, assault life. He's about that. I mean,
Take a picture of that. We'll show that to the jury.
yeah. I mean,
We're all familiar with the case of the police officer maybe a year or so ago who ended up shooting a suspect with an AR, and he had put on his dust cover, uh, "You're effed," or words to that effect.
yep,
And of course, the prosecution tried to get that admitted into evidence at the trial so they could show it to the jury because they wanted to use it to help explain to the jury, hey, we believe this guy acted with malice. Look, he was just ready to shoot somebody, right? The moment that dust cover opened, you saw "you're effed," and that was the message about his state of mind. Now, the defense managed to convince the trial judge not to allow that into evidence. So the jury, in fact, never saw that. And I hear people arguing, like, see, that guy had that on his gun and it didn't end up hurting him at trial. Okay, 2 points. First of all, that judge decided not to let it in. The next judge could decide to let it in. That judge's decision is not controlling on anybody else, and it's totally at his discretion. And you have no control over who your judge is or what decisions they're going to make. So you have no certainty at all that were you in that position with a different judge, that dust cover would not be admitted into evidence. It could easily go the other way. Second of all, he spent this defendant, this officer spent a lot of money in legal expenses arguing that the dust cover should not be admitted into evidence. That wasn't free. That cost him thousands and
mm,
thousands of dollars. Motions had to be written, arguments had to be made in court. That dust cover cost him a fortune in legal fees so that it would not be admitted into evidence. And by the way, he could have spent all that money and then it got admitted anyway. So he would have spent the money for nothing. And for what?
right.
Was it a better dust cover? Did it help his gun function better? It did nothing for him
Yeah.
in terms of winning the physical fight. All it did was increase his jeopardy in the legal fight.
Yeah, it's just not worth it. When you're sitting in the courtroom sweating, you're gonna really wish that you did not have that sticker, dust cover, what back plate, whatever the case may be. Sandra, we're sitting at close to an hour. This has all been excellent content, and we could talk forever about this. Honestly, I love this stuff. I've followed you for a long time and listened to you, and it seems to never get old. Even though when I hear you do cases now, I typically know where it's going, which gives me comfort because it tells me that I've learned properly. But I still love listening to it. But this is any closing thoughts here?
Yeah, so people will know that, of course, we have a book, we have live classes, online classes, DVDs. We do this for a living. So, obviously our goal is to also make money doing this. But the first thing we always urge people to do is simply go to our website because there's a lot of free content at the website. So we want you to access what we do for free before you ever spend a penny with us. And if you see what we do and you think it's value added for you and you'd like to buy something, that's awesome. If all you want to do your whole life is consume the free stuff, that's awesome too. That's totally fine. We're able to make that offer because, in our experience, once people see the free stuff, then inevitably they end up buying something too. So it works as a successful business model for us. But you don't have to pay anything. You can just go, you can download our free 5 elements infographic page, lawselfdefense.com/elements. Just go to our website, lawselfdefense.com. We have new free content available just about every day. Just take a look at the free stuff, enjoy that. And if you think you'd like to, learn more in depth, well, then we have other stuff that you could pay for as well if that's of interest. But at the very least, folks, please take advantage of the free stuff. Doesn't cost a penny. You're educating yourself and making yourself, as we say, harder to convict.
Bottom line, guys, go get the book. Go check out his content. Go check out the free content and get the book. I will tell you to get the book. Andrew's let me know that he's working on an audio version of this as well. For those of you who are kind of like me and are not great at always reading, which is why I love podcasts, because I still love to learn, but I'm just not the best reader in the world. I don't sit still very well. Bottom line, but that's go get the book, go check it out. If you're gonna carry a gun, even if you're not, go get it. But especially if you're carrying a gun, it's irresponsible to carry a firearm and not know a proper the laws of self defense and be educated on it so that you can you may be able to protect your family, but you also want to be able to go home to your family as well and not go to prison, jail, whatever the case may be.
I mean, who's going to protect them if you're in jail?
Yeah,
You're serving
exactly.
10 years on an aggravated assault charge. Who's protecting your family then? Right? That,
Ex-
that, that wasn't a win in a strategic sense, right?
Exactly. You have to be strategic and you have to think on multiple levels of this. It's not just about carrying a gun so you can shoot somebody or whatever you're thinking. You got to think way deeper than that. And I hate to say it, I'm not trying to insult anyone, but unfortunately, most people don't. I wish they would, but most people don't. So Andrew, your contact info. Let's get your contact info for the listeners. And by the way, I will have all this in the show notes as well.
Sure. The easiest thing for people to do, again, is just go to our website, lawofselfdefense.com. You'll see our blog there. We have new blog content just about every day. And in that stuff, we'll talk about other things you could take advantage of. We have memberships for more broader access to what we do. The lowest level of membership is free, folks. Bronze level membership doesn't cost a penny. Then we have various higher levels of membership. If that's of interest to you, don't feel obligated. But everything we do, you can pretty much find at our website, lawofselfdefense.com. Again, start with the free stuff. If you don't like it or you feel it's not value add for you, that's fine. We won't take it personally. A lot of people do find it valuable add, and hopefully you will as well. But wherever you learn this stuff, please learn it from someplace authoritative that's teaching you the actual law and not internet myths. If you learn the wrong stuff, folks, and you're carrying a gun, you're just setting yourself up to go to prison. And there's no reason for that to happen when the actual law is so readily available, much of it free at our website, lawselfdefense.com.
Gotcha. Well, Andrew, thank you so much for coming on today. I really appreciate your time. This has been absolutely awesome. I love talking with you and hearing all this stuff. Even though I've heard it before, it's still great to hear again. It's like any skill, use it or lose it, and it's great to refresh on it. So again, thank you so much for your time.
My pleasure. Anytime.
All right, Andrew. Take care.
Bye bye.